Hello and welcome to MensNet. My name is Tony Nazzaro and I'll be your host for tonight's program. Roy has the night off. Tonight we're going to be talking about joint physical custody. And joining us tonight, I have on my right Sal Lagonia, an attorney at law. And Sal, do you have a practice in Westchester?
I have a practice right here in Yorktown Heights, New York.
Okay. Also joining us, our old friend Stephen Metzger, a men's advocate and frequent guest.
Pleasure to be here again.
And Efren Rodriguez, president of the New York State Fathers' Rights Association.
Thanks, Tony. Great to be here.
Efren, I'll open with you. Being it's about joint physical custody, the question is real joint custody possible?
Well, we have to establish the fact in New York State that joint custody as a premise does not exist in law. You can look in all the family law books there are, but it is not within the purview of a judge to grant or order joint custody. And I say that with a proviso because yesterday I received a divorce judgment from a member of our organization where a judge in fact granted joint custody to the parties, and then the father was, what do you mean I have joint custody? I wanted sole custody. And the judge says, no, it's better you have joint custody because it doesn't disrupt the children. So you're going to move out of the house and she'll live in the house, and then when it's your time to leave, you'll move in the house and she'll move out. And they call that joint custody. I don't see how that is possible.
Well, at least it's equitable there. I mean, it depends on how many years you get to, be with the child.
Sure, certainly the age of the children is a factor, and there's other factors involved, whether or not there's domestic violence or anything like that.
That's quite an unusual decision.
It is, and in all of the cases, the joint physical custody has to be a consented agreement between the parties. As Efren said, it's not recognized in the law. There's no statute anywhere in any of the law books that says joint physical custody exists. Several times it's gotten as far as the Senate, and we haven't really gotten it through the Assembly yet. So the only way it's going to happen is if consenting parents say that this is the best thing they can do, and they have to consent with each other. And one of the reasons is very pragmatic. They want to make sure that the two parents are going to be able to communicate with each other. Well, by virtue of the fact that you've had a contest over custody, you are showing right there's some communication problems. So often that will make a judge want to say, maybe this is not appropriate in this case. I haven't read that entire decision, so I don't know exactly what that judge was thinking, but since there is no law on it, no statute on it, there's no way that some judge could actually order somebody to do that.
It's a little confusing, though, because they talk about joint legal custody, and at first I thought that meant physical. Steve, obviously I was wrong.
Well, I'm sorry, I wouldn't
About the legal, they called it legal.
Well, joint legal custody really amounts to pretty much a sole custody arrangement. It's just in sort of in legal, the status of it in some sense or another is a joint custody arrangement. But I think what we're basically talking two issues simultaneously here. One is whether it exists in the law, and I think we've covered that pretty well. The other question is particularly what lay people tend to ask is it really possible? Can you have, this kind of arrangement you're talking about here, Efren, seems really pretty wild. And actually, there have been some very, very unusual joint custody arrangements, always, with the consent of the parents usually, but there have been, transcontinental movements of the children, from 6 months here on the West Coast, 6 months on the East Coast. Literally that has happened. But the question is, can this be a formula, or can this be formalized where the average divorced couple, shall we say, can really handle it? I think that's the key question, and I think it can be, but my colleagues have.
But as Steve said, you're going into court for a divorce. That means the marriage is going to be dissolved. Mm-hmm. So now there's the issue of the children. In New York State, children are considered the gold. If you have the child, you own the prize. Right. You get the children, you get the child support. You get the children, you get the house. You get the children, you get the bulk of the equity of whatever existed in the marriage. So joint custody precludes that type of an argument. Would joint custody then mean that there's no child support, Sal?
No, not necessarily, and that's one of the biggest problems we have. I'm doing a case right now where it's going to be a very close to a joint custody situation on consent. The problem is, even if we get consent from the, in this case it would be the mother, we can't necessarily go to zero child support without a long deranged explanation to the appellate division, because those types of cases routinely get reversed on appeal. And so when you have custody, somebody has to have custody of the child. And judge after judge will tell you this, that we're going to call it joint custody, we're going to give you 51% and you get 49%, but somebody is going to be called the custodial parent and someone's going to be called the non-custodial parent. And that's where the major change in the law is needed.
Is that strictly so you have a direction for the funds to go?
Well, that's part of it. I think you also need to have somebody to be the default. You know, if I want him to go to Harvard and you want him to go to Yale, who's going to make the final decision? We have, and when you talk about the funds, and I think that's an important issue, we have the Child Support Standards Act in New York, and that is where we get our formula for determining child support. It doesn't work with joint custody. It works very well with sole custody. We even have some provisions in there where we can amend it so we don't actually have to stick to the strict stricture of the law. But when we talk about joint custody, where we're actually sharing the children, we're talking about maybe no net cost between the two. We still have to have something in the CSSA that's going to say this parent, the non-custodial parent, is going to be paying to that custodial parent.
And that's where the acrimony in the divorce actually comes. Because, again, like I said, if you have the child, you have the gold.
Right.
You get the prize. So we in the Fathers' Rights Association have always advocated that at the beginning of every divorce, presumptive joint custody should exist. There should be no money exchanging hands.
Now, but explain that. What, you know, to a layman, that they don't understand what that means.
Joint custody is akin to a separation agreement, all right? We're not living together, but we still have to parent our children. I'm going to continue to take care of the kids like I did. You're going to continue to take care of the kids like you did. That doesn't happen. What happens is one parent is a custodial, the other one's the non-custodial. The non-custodial now has to petition the court for visitation. Visitation occurs on these days, at these times, at this location. Then the other issue of enforcing that comes in. The custodial parent has a grudge against the non-custodial parent and won't allow the children to see the other parent. Where does that go? The premise of presumptive joint custody means that I have the same rights you do to the children, we're just not living together.
Right, but the word presumptive, that's what's throwing me. I don't understand that.
Presumptive it basically means that there's a presumption that both parents will equally share in the upbringing of the child. That's what it means, and it doesn't mean that it's going to. It's a rebuttable presumption. I mean, you could bring evidence that one of the parents is totally unfit, and therefore, that the certainly this is not the custodial arrangement that you want.
So there wouldn't be any harm having presumptive joint custody then?
Well, yeah, absolutely not. I mean, most of the advocates against joint custody say, well, you can't force the judge to declare joint custody. Can't be forced to do that. Shouldn't be forced to do that. It's a total red herring. It's not what the law says at all.
And remember, most states allow it.
Yes.
New York is one of the few states that don't. I'll give you the most egregious case. It's a case I finished about a year ago, where mom and dad lived together, they got divorced, and they lived in the same school district, and the children lived with mom, and mom got child support. She was the custodial parent. Dad saw the children a lot, but mom decided to move across the river, and now she's in a different school system. The kids wanted to stay in their school system, so they moved in with dad, and they stayed in with dad. I could not get child support to go to zero in that case until I had a change of custody. And that change of custody took over 8 months. Even though dad was footing the bill, I happened to be a mathematician, which was wonderful for me because he had these pie charts that showed that they had the children 87.32% of the time. But I mean, that helped me in the courtroom, but the judge still had to make a decision that custody be changed before he could get rid of the child support.
Right. And then you speak about going across a river. What about going across a country? You have bi-coastal children now in these presumed joint custody arrangements where they'll live 6 months of the year on the East Coast and 6 months of the year in the West